Recording in progress.
Good morning, everybody. Welcome to the Consumer Warranty Workshop, Understanding Your Rights Under California and Federal Law, a Guide for Consumers. The Consumer Warranty Workshop is presented by Public Law Center and funded through a generous grant from the Rose Foundation for Communities and the Environment. Next slide. So let's go through a few housekeeping items. Number one, we are going to be sending a post-workshop survey to all the attendees. Please fill it in and return it to us. This is going to help us to make sure that these workshops are fulfilling the needs of the people that attend. Second thing is that we are recording this workshop. The recording will also be available after the meeting. We've got 4 different templates that we're going to refer to in the workshop, and you can get copies of those if you send a request. PowerPoint, we will send you a copy of the PowerPoint if you request it. And if you've got any questions, please feel free to drop them in the Q&A, and I will keep an eye on the Q&A. There's also a translation ability in Zoom. If you click on the closed caption button down below on Zoom, there's a little caret, a little kind of a upside down triangle that you can click and choose a language that you'd like to have the meeting translated into, and you should get therefore a feed on the bottom of your screen that will translate the words that I'm saying into the language of your choice. So here's an introduction to consumer warranty law. Consumer warranties, consumer warranties are governed generally by state law, but there is a very large federal law that applies also to consumer warranties. Now, today we're going to just be talking about the big California consumer warranty law and the big federal consumer warranty law that we use most of the time in our practice. And using these warranties, you will be able to demand repair, replacement, or refund from a seller or a manufacturer. Now, why are warranties important? Just try and move something out of the way. There we go. Um, Why are warranties important? Well, are important because they protect consumers from defective products. They are essential for ensuring that manufacturers uphold product quality, and they also can stop us from discarding products and overloading our landfills. So there's 2 basic types of warranties that I want to talk to you about before we get into the weeds of the actual California and federal laws that we're going to be discussing today. The first type of warranty is an express warranty. And an express warranty is a written or verbal guarantee that's created by the seller or the manufacturer. And this can include documents that the seller or the manufacturer gives you when you purchase the product. It can include signs posted in the store that talk about the types of warranties or guarantees that are included on the product you're purchasing. And it may also include samples and models that are shown to you before the sale. Those can all be considered a type of express warranty. Of course, anything in writing that warranties the product is the very definition of express warranty. We also have implied warranties. Now, these are warranties that are not written down or actually spoken in general by the seller or the seller or the manufacturer, but these implied warranties come into fruition based on operation of law. That means you don't have to do anything. If there's certain circumstances met, your implied warranties come into play. So the two implied warranties that we're going to be that we want to think about today are warranty of merchantability and warranty of fitness for a particular purpose. Now, again, these are implied warranties. So these are warranties that you likely don't know about unless you're watching a seminar like this. And these are enforceable, just like express warranties. So it's important for us to know these. So warranty of merchantability says that the product is fit for the ordinary purpose that you would expect that product to be used for. So let's say you purchase a brush. That brush is going to be able to take the tangles out of your hair. If there aren't any, if you buy a box that has a brush in it and the brush doesn't have any bristles, well, that's obviously not fit for the ordinary purpose of a brush. Let's look at another example. Let's say this coffee mug. If I buy a box that says coffee mug and I open it up and what's inside is not a coffee mug, then that's a violation of the warranty of merchantability. And the other thing is that the product will do what you expect the product to do. So if you buy a toaster, the toaster's going to toast. If you buy a vacuum cleaner, it's going to vacuum. Those are the basics. The box has to be properly packaged. The item has to be of just average quality, not bad quality, not superior quality, average quality, properly packaged and labeled. And we can bring claims based on this if there are any kind of problems with something like that. Like if you buy an electric bike and you open it up and there's instead a Roomba in it and not an electric bike, well, that's a violation of the warranty of merchantability. Now, the other implied warranty that's important is the implied warranty of fitness for a particular purpose. And this warranty is only comes into play if the seller knows the particular purpose that you are buying the product for, and you buy the product based on the seller's recommendation. So it has to have those couple of things in place. And of course, those are things you're going to have to prove. So you want to pay attention to what you're buying and what they're selling, and make sure that if you have provided the seller with information about what you are looking for a product to do, and they recommend product A to you, and you buy that product because of the recommendation of the seller, then if it doesn't do what the seller sold it to you for, then there's an ability for you to file a claim based on violation of implied warranties. Now, these can be disclaimed. Implied warranties can be disclaimed, so a manufacturer doesn't get blindsided by a warranty claim that they weren't expecting, but it can only be disclaimed if the receipt or another document that's given to you at the time of the sale has the words "as is" on it. So everybody's had the experience of purchasing a used car where you buy it from another individual and the individual writes "as is," or even if you buy it from a dealer, that probably makes more sense to talk about. When you buy a used car from a dealer, sometimes they'll give you a short warranty. Sometimes they'll try to sell you a service contract on top of the warranty. Sometimes the car is as is. And when a receipt says "as is," you better believe it. There are no warranties on that product, and none of these laws will work for you if you are purchasing a product that is as is. Now, that's the only way that somebody can disclaim an implied warranty. But if there's an express warranty in place, the seller or the manufacturer cannot disclaim the implied warranties. So it's either no warranties or the warranty that's given expressly and the applied warranties that apply. So in California, the two big warranty laws that you should know are, number one, the California Lemon Law, which is a state law that is also known as the Song-Beverly Act, and the Magnuson Moss Warranty Act, which is a federal law, and it's also known as Mag-Moss. And the citations are there if anyone's interested in looking up the actual text or of the statutes. So we're going to talk first about California's lemon law, the Song-Beverly Act. I can see that you guys, I think that my screen is being partially obscured by this black piece up top. Oh, there, it went away. Thank goodness. Okay, perfect. So, California lemon law, Song-Beverly Act, same thing. Most people know this law as a law that applies to cars, and I'm here to tell you that it does not just apply to cars, but exactly the same way that it does apply to cars, it applies to all consumer goods that are sold at retail in California. So, sorry, I said all consumer goods, but let's carve out food and clothing. Food and clothing are not covered under the Song-Beverly Act, but every other consumer good that's sold at retail in the state is covered by the Song-Beverly Act. So what's exactly a consumer good? That's a product that's purchased primarily for personal, family, or household purposes, which in a nutshell means that if you are purchasing a product for, let's say you've run a small business and you buy a product, that a vacuum cleaner that you're going to use in your small business, that's not going to be covered under California's lemon law because you didn't buy it primarily for personal, family, or household purposes. So I think that's pretty clear to everyone. So what does the lemon law require? It requires that a manufacturer or a seller either refund you or replace a warranted product if it cannot be repaired within a reasonable number of attempts. Usually, the consumer must deliver the product to an in-state repair facility within the warranty period, but there are exceptions for items that are too large for you to do that, such as a giant freezer that you buy to keep in your basement to keep all your frozen food. It is probably not going to be required that you have someone come in and move that freezer for you so you can bring it to the repair shop. There's likely another solution. But with most consumer products that are movable and or shippable, you probably will have to deliver the product to one of their in-state repair facilities. Now, if you don't bring it to one of their repair facilities, you are certainly entitled to bring it to any other type of repair shop that you like. They can't require that you use a certain repair facility, but it's often easier and streamlines the way down the road if you bring it to one of their repair facilities. It takes away one of their oftentimes excuses of, well, you didn't let us try to fix it, you let someone else try to fix it. Not a valid excuse. And I'm going to talk to you later about how you can challenge that. But if you want to avoid the problem, bring it to one of their in-state repair facilities. And one thing that I learned from preparing this presentation is that in California, a seller and or manufacturer must have in-state repair facilities available to us for a certain period of time after the manufacture date of the product. If a product has a wholesale price of between $50 and $99, there has to be an in-state repair facility available for 3 years. And if it's a product with a wholesale price of $100 or more, there must be an in-state repair facility available to us for 7 years. So it's a great way to try and get your product repaired and to see if you can get your warranty claims enforced. And of course, the Song-Beverly Act does allow for a private right of action, and it allows you, the consumer, to request reimbursement of your attorney's fees. It's not a given that you're going to get the attorney's fees. You're going to have to ask the judge for it. So it really is a discretionary decision. But the possibility of it means that a lot of attorneys will take on these cases, especially higher ticket items like cars. A lot of attorneys will take on these cases because they know that there's a possibility that they're going to get paid by the other side. Um, okay. Can't move it. There we go. It jumped way, way, way ahead. Sorry about that. Okay, so let's talk specifically about how to enforce your rights under the California lemon law. So, number one, you want to confirm that your product is covered. So, how do you know if your product is covered? Number one, the product it must have been sold with a warranty. Again, remember express or implied. Implied, they don't even have to tell you about. But if it's not written as is, that implied warranty is in existence. Number two, the product must have been purchased in California. And don't forget the original requirements of consumer product, not food or clothing, sold at retail in California. So also the product must have a defect and the defect must substantially impair the product's use, value, or safety. So that means that not all defects are covered. Let's go back to oh, you can't even see my little coffee cup. Oh, there it is. So let's go back to my coffee cup here that I purchased. And let's say that there's a scratch over here on the body of the coffee cup. You may not like the scratch, and you may be angry that you bought a $25 coffee cup and there's a scratch on it, but that's not something that's going to be warrantable because that defect does not substantially impair the product's use, value, or safety. Now, on the other hand, if this coffee cup had a big gouge in the spot where you drink from, well, that then is probably a defect that would be covered because it does substantially impair the ability of you to use the coffee mug and it impairs the safety of the coffee mug and by implication, of course, the value. So, not all defects are covered. It depends on if the defect affects the use, value, or safety of the product. It's not usually a hard prong to meet, but it does eliminate of certain de minimis claims that might otherwise come before the court. So, step number two, you want to make a reasonable number of repair attempts. The statute doesn't quantify what reasonable means. And so that tells us a couple of things. Number one, it tells us that it's the standard lawyer answer of it depends, right? We always say often when attorneys are asked a question, we often say it depends. Here I'm going to say it depends. If it's your automobile and you need your automobile for work and you've brought it into the shop two times and they are not able to fix the problem, two times is likely going to be enough. If you're talking about, let's go back to my coffee mug example. If you're talking about the coffee mug and they're trying to fix the chip in the lip, then probably one time is enough, is a reasonable amount of times to try and get that repaired. So, see, it depends on the type of product and it depends on the type of defect. And this is something that the judge is going to decide. Rule of thumb, two attempts should be good enough. Three attempts, surely good enough. That's just a rule of thumb. Now, you should document each time you try to make a repair attempt because obviously, if the statute says you have to make a reasonable number of repair attempts and you go ahead and make three repair attempts, you want to make sure that you can show the court that you actually did make those three repair attempts. So if you've got receipts, that's the best way to show it. If you don't have receipts, but you've got written down in your calendar or in some kind of notebook, visited Joe's repair shop on this date, told them this, they said they couldn't repair it. And that should be sufficient for showing that you made these repair attempts. So step number three is you're going to gather all the evidence for your claim. And so far, the evidence that we have is just the receipt from when you purchased the product, the written warranty, if you have a copy of it, or maybe you can get a copy of it online. You want to definitely keep all of the receipts or paperwork that you get from whatever repair facility that you use. And if you've had any communications with the seller or the manufacturer, like you purchased a phone from Best Buy and you're having trouble with it, so you email Best Buy and you say, having trouble with the phone, what am I supposed to do? And they respond, well, that's a nice piece of evidence for when you notified the seller that the product was defective and what they said about it. If you have text messages, take screenshots of the text messages or email them to yourself. If you've got emails, if you go on the manufacturer's website and you make a claim there, please take a screenshot or take a print, do a print of the form before you submit it. Oftentimes, we make complaints on websites and we don't get confirmation that we made that complaint. And because it's in the infrastructure of the seller or the manufacturer, you might not be able to get a copy of that. So you need to make sure that if you're making a claim or communicating with the seller or manufacturer, you've got a way to prove that you've advise the seller or manufacturer of the problem. Another good thing to do if it's a like let's say the vacuum cleaner issue. Let's say you decide you buy a vacuum cleaner and you get home and the vacuum cleaner just doesn't pick up a speck of dirt. It'd be great to have a little, 15-second video showing here's some dirt, here's the vacuum cleaner turned on and roll over the dirt and show that it's not picking up the dirt. That's a really good piece of evidence for the judge to see so that you can prove that the product is not functioning without having to actually bring the product into the courthouse. So, step number four, remember, step number one was that you made sure the product was covered under the warranty. Step number two was you tried to get the product repaired. Step number three is you start gathering all the evidence that you have for this problem. And step number four is you're going to take all this information and you're going to notify the manufacturer or the seller in writing about this problem. So how do you do that? You send a formal demand letter via certified mail, return receipt requested. We've got 4 templates already prepared for you to make these claims to a seller or a manufacturer. We've got all the law written in there, and all you have to do is fill out your own personal details, information about the product, and information about the defect and the attempts to repair that you've made. So it's just basically summing up everything that we've talked about so far, putting it in a letter to the seller or the manufacturer or both, and sending it by certified return receipt requested. Now, why do I say to send it by certified return receipt requested? Because that, by the way, that requires a trip to the post office and the cost is about just under $10. But here's what's important about that. Number one, you're going to be able to prove that you sent this demand letter to the seller or the manufacturer. You're going to have a receipt that shows that you brought a letter to the post office and sent it off to the manufacturer. And of course, you're going to keep a copy of that letter for yourself so that you can not only prove with the receipts that you mailed it, but you're going to keep a copy of the letter that you actually sent. And the return receipt requested part means that we've got a mechanism to prove not only that you sent the letter, but that the other side received the letter, because the post office won't deliver it to them unless they sign a green card that is sent back to you. So now you've got proof that they received the letter. These are really good pieces of evidence for you if you end up having to sue the seller or the manufacturer. And I tell you, once they know that you are documenting this claim and you're sending things by certified return receipt requested, they're going to know that you're not someone to be messed with. And the likelihood is higher that they're going to try and settle with you or give you a repaired product or a refund or a replacement product. But it increases the seriousness with which the seller or the manufacturer will take the claim. So the seller or the manufacturer, once they get your demand letter, they may require you to participate in arbitration at their expense. So arbitration is kind of a non-court judicial proceeding. So there's an arbitrator who each side will tell their story to, and the arbitrator will explain his or her thinking to both sides and will make a decision. Now, here's the very important thing here. That decision is not binding on you. That means you can ignore the decision and move ahead how you would have anyway. Binding arbitration is something else. That's not, you're not required to do binding arbitration here. It is only non-binding arbitration, and they can't ask you to pay anything for the arbitration. If they want you to participate in arbitration, it's on their dime. So you don't put a dime out of your pocket, but if they ask you to participate in it, you should. So here is a copy of one of the demand letters. This is a Song Beverly demand letter to a seller. And what we also have in the handouts is a Song Beverly letter to the manufacturer. We have a Mag Moss letter to the seller and a Mag Moss letter to the manufacturer. So we've got all your bases covered. I would probably send all four letters, two to the seller, two to the manufacturer. But if you only send the ones to the seller, or if you only send the ones to the manufacturer, it's all still good. None of that is going to get you thrown out of court. So the letters that we include are in Word format so that you're going to be able to just go in and edit them. And the places that we want you to edit are the places that are highlighted in yellow. Everything else you can leave exactly as is and only replace the parts that are in yellow. So when you finish with the edits to this letter, after you put your own information in there about your situation and your product, you shouldn't have any yellow left on the document. You should sign it and make a copy of it and then send it by certified return receipt requested. Now, can you see my little pointer there? No, I don't think you can. Oh, here we go. I think you can see that pointer now? I hope you can. Anyway, right here you can see that I wrote via certified mail number and I have a big long blank. So I always put the actual number of the certified mailing right there on the letter so that there's no doubt that this is the letter that I sent with that particular certified mailing. I do this because that actually happened to me once in court. I showed that I sent a certified mail return receipt requested, and the other side said, that's not the letter we got. They claim that they never got the letter anyway. And so now, let me see if I can show you this. This is the return receipt card that gets pasted on the back of your envelope, and that will come back to you with the seller or the manufacturer's signature on it. And this is the certified mail receipt, which tracks the fact that you brought this letter to the post office and mailed it off. And one of the things you might not be able to see here is that on the very top, there's a tracking number. It's on the top and it's also in the middle. That little piece on the top peels off. So you can peel that sticker off and you can stick it right there on your letter, or you can just copy the numbers. But in any case, that's a tracking number for your letter. So for under $10, you get your letter tracked and you get proof of receipt. Well worth it when you're thinking about bringing a claim against a seller or manufacturer for a warranty issue. So these templates are available to everybody that participates in this, everybody who watches this video. If you'd like copies of those letters, please email us at cww@publiclawcenter.org. CWW stands for Consumer Warranty Workshop. cww@publiclawcenter.org, and we'll send the templates right off to you. There we go. I had annotate on, so it wasn't changing. So after you send this letter, if you do not hear a response from the seller or the manufacturer within a certain amount of time, you may have to file a lawsuit. Usually in the letter, I give them about 30 days to respond. So I mark my calendar for about 35 days after the day I send the letter to do my follow-up. Let's see if we got a response from them. If not, let's move on to the next steps. So, what are your next steps? Well, if you want to be very aggressive, you can file a lawsuit right then and there. You could, if you want, send another letter saying, following up on my letter of December 10th, haven't heard from you. Should I expect a response? I don't know if I would do that. I think once you've already sent them a demand letter and they've refused to respond, I think that your claim is already teed up. But if you want to show the judge that you are bending over backwards to give them the benefit of the doubt, and you send another letter, it's not going to do anything but help your side, to be honest. It's going to cost you a little bit more time. You don't have to send the second letter by certified return receipt because all you need is proof that you made your warranty claim on a certain day, which is what that demand letter and what that those receipts give you. So if you follow up with a second letter after the demand letter, no need to send that by certified or return receipt. And as I said, no need to even do it. You can move right ahead to a lawsuit. So let's talk about what the lawsuit would look like. Under this California lemon law, the claims basically are breach of the written warranty. So that's breach of the express warranty is probably a better way to put it. Breach of the implied warranty, if that applies, and violation of the Song-Beverly Act. So you could keep it really simple and just make those three claims. You can also do it yourself. You do not need a lawyer for this. You can go to small claims court if the amount is up to $12,500. And in small claims court, attorneys are not allowed. So even the other side is not going to have an attorney if you do small claims court. So that's my recommendation for most people if their product is under $12,500. If the product is over $12,500, then you're going to have to file in Superior, either civil limited or civil unlimited. Attorneys are allowed here. It's a little bit more I think it's fairly more complicated than small claims court, and you might need a little bit extra help, but it's still doable by someone who is willing to go through the self-help steps that are listed on the website. And California's occourts.org has a really beautiful self-help section. So if you need help in filing a claim, that's the place to go. So let's now move on to the Magnuson Moss Warranty Act. So remember, Song Beverly, the California lemon law is a state law. Mag Moss Warranty Act, Magnuson Moss, same thing. That's a federal law. Now, even though we're in California and even though we're going to file this claim in state court, we can bring a claim under a federal statute, Mag Moss Warranty Act, especially because we're anchoring the complaint with a state law claim. So our state law claim is breach of the Song-Beverly Act, and then we're going to also add a claim for breach of the federal Mag Moss Warranty Act, and we can put those all in the same lawsuit and let the same judge make these decisions based on both of these laws. So let's talk about a little bit about Mag Moss. Mag Moss is a federal law that regulates, simplifies, and standardizes consumer warranties. So remember, I said in the beginning that most warranties are creatures of state law, not federal law. This federal law was developed as a way to standardize warranties around the country so that there weren't thousands of different types of warranties and ways to enforce warranties. It's just a way to make sure that consumers know what they have to do if they're trying to get their product replaced or repaired. So, back when we were talking about the Song-Beverly Act, I said that the product has to be sold at retail. Excuse me. And for purposes of the Song-Beverly Act, excuse me, for purposes of the Song-Beverly, Act, you cannot, um, if you purchase a product from an individual, like let's say I go and I buy a printer from uh, somebody who advertised on Nextdoor, and this is just somebody who lives down the street and is no longer using their printer and they sell it to me. That sale is not covered under the Song-Beverly Act because it wasn't sold at retail. Now, if you have a neighbor who runs a small business selling used refurbished printers, now we've got a different situation. Now we have somebody who is in the business of selling printers, and that counts for Song Beverly. But just a neighbor to neighbor sale from a person that is not does not do this regularly, that's not going to be covered under Song Beverly. But Mag Moss, on the other hand, if there's a written warranty, no matter what, Mag Moss applies. So Mag Moss is a way to standardize not just consumer warranties, but written consumer warranties. So let's go back to me buying a printer from my neighbor who just lives up the street and doesn't sell printers as a regular thing. So I go to the neighbor and I say I'd like to buy this printer, and the neighbor says it's going to be $100, and I say, well, I only want to give you $50 unless you give me a 30-day warranty that it's going to work for the next 30 days. So if the seller writes down printer sold, 30-day warranty, $50, then you have a written warranty, right? So under Magmoss, it doesn't matter who the seller is. It just matters that there's a written warranty. It's the only thing that matters. So Magmoss says that written warranties have to meet certain standards and contain certain disclosures, otherwise, it's a violation. Also, Magmoss sharply restricts disclaimer of implied warranties. Also, Magmoss provides for attorney's fees if the consumer prevails in the action. And of course, actual damages are still available based under your state law claim. So if you've got actual damages, we would likely assert them under the state law claims. The one thing I haven't mentioned yet about the Magmoss Warranty Act is an additional place that it applies are in service contracts that are purchased from either the seller, the manufacturer, or a third party. And these are, I guess mostly they're called extended service contracts. So let's say you buy the vacuum cleaner, it has a 30-day warranty, and while you're paying for it, the cashier says, well, would you like to add additional warranty on that for $9.95 a year? If you say yes, and if you get that additional warranty is actually called a service contract under Magmoss, and it is actionable under Magmoss. So your service contract is something that you can use Magmoss to enforce against the seller or the manufacturer. So here are the three basic rules of Magmoss. Number one, warranty must be clearly disclosed, and it must indicate one of two things, either full warranty or limited warranty. It must have one of those two words, full or limited. Now, if they give a full warranty, it must meet very strict standards under Magmoss, including free repair and refund or replacement after a reasonable number of repair attempts, just like Song Beverly. So sadly, most warranties that we get nowadays are not full warranties. You are likely only going to see the words limited warranty on your warranty. But the warranty must be clear. You must be able to unread it and understand what's actually being covered. They can't use legal language. They can't put something in there that is not made for a regular consumer to understand. The warranty must be in a single clear document, and the warranty must be available pre-sale, either physically or electronically, so the consumer can take a look at it before purchase. So let's talk about the prohibitions under Magmoss. Number one, if there's an express warranty sold with the product, it's illegal to disclaim the implied warranties. Now, that sounds like it should be understood, but until Mag Moss, there was no way to enforce that rule. So now we know that this is the way to enforce if they try to disclaim implied warranties. Now, the only thing they can do, a seller or a manufacturer I'm talking about, the only thing they can do with respect to implied warranties is under Mag Moss, they can limit the duration of an implied warranty to the same duration of the express warranty. So remember, I told you if there's an express warranty, they cannot disclaim the implied warranty, but they can amend it to match the time frame of the express warranty. That's the only change that they can make. As I said before, they can have misleading terms. They certainly can't have deceptive terms in the warranty. You should be able to understand it. They are not allowed to have tie-in sales, which means they're not allowed to say to you, you have to buy our let's go back to the printer. You have to buy our toner for your printer, otherwise your warranty is voided. Absolutely not. That's against the law. That's actionable under Mag Moss. So if they say that to you, you push back on them and tell them. And believe me, it happens. I actually had it happen not too long ago with my personal HP printer. It was defective. It was within the warranty period. When I say it was defective, it wasn't printing. So it was within the warranty period. I actually contacted them 9 separate times to try and get it repaired. And they kept saying it, they couldn't repair it. They just kept giving me the runaround, to be honest. And finally, I was about a week away from the warranty and the end of the warranty, and I just knew I had to either push the issue or make a formal demand warranty claim to preserve my rights under the warranty. And so I got a rep on the phone who asked me to take a photograph of the toner that I'm using. This is one of the things that they do. And they could see that the toner was Amazon brand, not Hewlett Packard brand, and said to me on the phone, your warranty is voided because you didn't use Hewlett Packard toner. So I'm laughing because people that know me know that I'm not the right person to lie to about something like that. So I have a brand new Hewlett Packard printer right behind me, and it's full of Amazon toner, and it's working just fine. They sent me a brand new replacement printer. So these laws work. Knowing your rights works. Not being afraid to assert your rights works. I highly recommend it. Makes me feel powerful. So many times nowadays I feel that corporations are taking over the world and I've got no power. We as people down here don't have any power left. So I love these kind of laws that allow us to assert our power and our rights against these people who seek to take away our rights so that they can increase their bottom line. I've got a real problem about that. So new HP printer. Thank you very much. So here's another thing that they can't require you to use a particular repair company. Like if, let's say I called them and they said, oh, you have to bring it to, you have to drive up to Sacramento and bring the printer to a certain repair company. No, they can't require me to do that unless it's free to me. Like unless if they decide they want to come and pick it up, or if they want to send me a shipping tag so that I can just give it to the UPS guy here in my building, that they can force you to do, but they can't force you suspend your time and your money to bring it to a particular repair facility that they have. They can't do it. They can't disclaim your warranty because you broke a seal. With one exception, if it's one of those products that has some kind of electrical thing that's dangerous on the inside. I don't know anything about electronics, but I do understand that they used to lock down the backs of electronic products so that we couldn't open them because supposedly there was something that could shock us once we took the back off. So if there's a safety issue with taking the back or off the product or taking the product apart, it's possible that you're taking that product apart voids the warranty. But in general, right to repair is pretty strong right now, believe it or not, in the United States. So most sellers and manufacturers understand that we all need the right to repair these products, especially higher ticket items. And I'm particularly talking about cell phones because that's where I saw a lot of break the seal disclaimers um, when people make warranty claims. So the last prohibition that I want to talk to you about is that they cannot require you to return a warranty card to obtain warranty service. The warranty rights are set at the time that you purchase the product. So they can't say, oh, your warranty's not in force until you send this warranty claim, this warranty card. What they often do is they say, if you'd like an extended warranty, like we'll add 30 days to your existing warranty, if you fill out all the data on this warranty card, feel free to do it. You can go ahead and do that and get the extended time, but they cannot force you to fill in that warranty registration card just to get your warranty coverage that you've already paid for. So don't fall into that trap either. If they ever call you to say, if you call in a claim and they say, we didn't get your warranty registration card, you're going to be like, oh, I remember what Suzanne told me about that. That's a bunch of hooey, and they're not going to get away with it. I love a powerful, informed consumer. Okay, so now let's talk about the remedies. So remember, as I said earlier, Magmoss doesn't create the remedies under warranty law. State law, like California lemon law, creates the remedies. What Magmoss does is gives us an additional federal cause of action for violation of written warranties. And of course, it's another way for us to ask for attorney's fees. So when you're an attorney, the more statutes you have that allow for you to ask for reimbursement of attorney's fees, if you had to sue someone because of something that they did, then the more likely it is that we're going to get our attorney's fees reimbursed. And I'm not happy about this because I want attorneys to get paid. I'm happy about this because if attorneys can get paid from the other side, then attorneys are more likely to take your case without you putting out money to them. So that's why these kind of attorney fee provisions are really important. It's also helpful for settlement purposes. If a manufacturer thinks that they might be on the hook for your attorney's fees, they're probably going to think twice about settling. Really, I think what they do is they calculate that risk into their calculation of whether it's worth fighting this claim or not. So the more we have on our side of the scale, the better it is for our settlement purposes. So under Magmoss, just like under the California lemon law, arbitration, or what's often called informal dispute resolution, IDR, that just means resolving things outside of the official courthouse. And there's arbitration, there's mediation, there are a lot of things, a lot of ways we can negotiate with a seller or a manufacturer or any opposing party for that matter. But that's encouraged to avoid lawsuits. Judges, when you file a lawsuit, a judge wants to see, in general, that you've exhausted all of your available avenues of remedy before you come to the court to say, I need the court's help on this. I know that sounds a little strange because the court is supposed to help us all the time with everything, but because the courts are so overloaded and underfunded, it's difficult for them to feel happy about all the claims that they get. So they are looking for us to solve our own problems to the extent possible. And especially if there are attorneys involved, they really want attorneys to try and work things out without having to go through an entire court process. So let's go through how to enforce your rights under Magmoss, just like I went through how to enforce your rights under California lemon law. So step one, you want to determine if your product is covered. So the product must be a consumer product sold with a written warranty. And don't forget, we also include service contracts here under MagMoss. Um, and again, covers used products, new products, any product that is sold with a written warranty. Now, again, remember that if the written warranty says all it says is as is, and on obviously that's not a warranty, but if the receipt says as is, Magmoss is not going to help you. California lemon law is not going to help you. That's a buyer beware situation. You are literally buying that product as is the moment you step away. The moment you step away. Um, so the warranty must have been provided by either the manufacturer or the retailer or the third party service provider. It has to be written. The warranty must still be in effect. So if it's a 1 year warranty, you're within the 1 year period of purchase. If it's a 30-day warranty, you must be within the 30 days. Otherwise, that's it. That's a hard deadline. That's it. It's over. So another, and again, just like under Song Beverly, the product must have a defect that the warranty covers. So you want to take a look at the warranty. This generally comes into play with things like automobiles where the dealer will warranty, let's say, the drivetrain, but nothing else. So if your warranty issue originates in the drivetrain, that should be covered. But if your warranty issue originates like in the electrical system, that's not going to be covered. So you want to make sure that whatever your defect is, whatever the problem is, you want to make sure that it's covered under the express terms of the warranty. So step number 2 under MagMoss is that if the manufacturer wants you to do informal dispute resolution, you must do it. But just like under the California lemon law, must be free, and it must not bind the consumer. So if the arbitrator or the person running, the mediator running the informal dispute resolution decides that you don't have a claim, you could just ignore them and go ahead and file a lawsuit anyway. So that's what it means that the arbitration is not binding or the informal dispute resolution is not binding. They can force you to do it, but they can't force you to accept the results. So similar to the California lemon law, under MagMoss, you must give the warrantor a reasonable opportunity to cure. Now, under MagMoss, you don't even get into court unless you can prove that you've given the seller or the manufacturer a reasonable opportunity to cure. It's what we call a jurisdictional requirement. You don't even get into court without meeting that jurisdictional requirement. So you want to contact the warrantor and you want to describe either phone, email, however you want to contact them. Remember from earlier, keep copies of all the times that you contact the seller or the manufacturer or the service contract provider. Make sure to print them or save them to PDF if you're doing it on your computer, or to print your screen and save it if you're doing it on your phone. You want to provide access to the product for the seller or the manufacturer to inspect it, and you want to request them to repair it. And again, we're giving them a reasonable opportunity to cure before we're bringing a lawsuit. Now, step 4, if your defect has not been cured after you gave them the opportunity, you can go right ahead and sue right now. You don't have to send a demand letter. You can go ahead and sue under MagMoss. But again, we want to show the court that we're trying to solve this on our own and we're being reasonable. We're not just jumping to a lawsuit at first. As soon as we have a problem, we're going to try and get the manufacturer to fix it. So I would send a demand letter. It shows that you're operating in good faith. It also proves that you contacted the seller, the manufacturer, or the service contract provider, and it shows that they received your letter. So I like the idea of using a demand letter and sending it by, excuse me, by certified return receipt requested. But if you want to, you can skip this step. And again, we've got templated letters that you can adjust for your particular purposes. Excuse me. And or you can go right ahead to a lawsuit. Now, if you don't receive a refund or replacement after this, let's say that you send them a demand letter, you wait 30 days, you wait another couple of days, and you haven't heard anything, then you might have to file a lawsuit. And just like under the California lemon law, you can file this in small claims court if the claim is up to $12,500. Remember, there's no attorneys in the small claims court. Um, or if it's over $12,500, you can file in civil limited or civil unlimited in state court. Generally, we don't file these claims in federal court. The only times you will likely see a Magmoss claim filed in federal court is if it's a nationwide class action, uh, because in federal court you have to meet a certain dollar jurisdictional requirement. So you have to have damages of over, I think it's exactly $75,000 or over. And these claims generally do not rise to the level of $75,000. There could be times that it does, and you might want to file in federal court. But as a non-lawyer, it's easier to file in state court. It's easier to run a case in state court than if you have to do it in federal. So my recommendation would be state. Also, don't forget occourts.org self-help section. Very, very good, very easy to understand. So feel free to go there to see how you bring these claims. So just like under California lemon law, if you're successful in your lawsuit, you could get a full refund or replacement. And that includes if we're talking about a high ticket item like a car. Doesn't matter. The warranty law is the same. You could get damages, out of pocket expenses that you had to lay out in order to get your warranty claim enforced. Those are likely reimbursable, assuming that you win the case. And of course, attorney's fees and all the little costs that you have along the way. Just filing a case in Superior Civil Unlimited is something like $435, I think, right now. It's expensive to file a case, but you're going to keep track of all of those things that you spend, including the money you spent at the post office when you submitted your certified return receipt request. All of those little costs add up. Make sure you're keeping track of those so you can get reimbursed or at least ask for them to get reimbursed from the other side. And just like under the lemon law, the claims are breach of written warranty, breach of implied warranty, violation of Magmoss, and likely we're going to have a violation of Song Beverly as well, which is why I added this. So these are the four claims that are the magic to get your California consumer warranty rights vindicated. So here's just a couple of consumer tips. Um, if you're buying a high ticket item, I would take a look at the warranty. I'd at least want to know how long the warranty goes for because I'm a bit of a procrastinator. I don't know about you guys, but if I know, like with my printer, I knew I only had 5 days left. And so I was adamant about making sure that I got my printer warranty claim in time. Now, if I hadn't known that my warranty was expiring in a week, I might have missed it. If I had just procrastinated a little and let it go till next week, I would have been out of luck and I'd be sitting here with a useless hunk of junk printer on my desk. So you should at least know when your warranty goes to. You want to keep all your receipts, keep your repair records, and obviously, the higher the price of the item, the more strictly I would follow these tips. And beware of warranty exclusions and time limits. This is all, I'm really saying all the same thing. You've got warranty rights. Make sure you claim them while they're still in force. So that's my entire presentation for the day. I'm going to look out to see if we've got any questions in the room. I don't see any questions in the Q&A. Let me just give it another second to see if anyone wants to drop a question in there. You could put one in the chat too if you want. All right, well, Seeing none, I reiterate that if you would like a copy of anything that I've discussed today, either the PowerPoint, the recording of this session, or the templates that we've created, please email us at cww@publiclawcenter.org, cww@publiclawcenter.org, and I'll email you back with whatever it is you asked for. We'd like to thank the Rose Foundation for providing the funding for this workshop. I am Suzanne Iazzetta. I'm an attorney at the Public Law Center in Santa Ana, and I thank you so much for attending our consumer warranty workshop. Bye.